Workplace harassment. It's kind of the elephant in countless offices, isn't it?
It really is. Sartre said, hell is other people.
Yeah.
And yeah, a toxic workplace can definitely feel that way.
But it's more than just bad vibes, right? We're talking about the real damage, the legal stuff, the financial fallout. It can be massive.
Absolutely massive. And often this damage just, simmers under the surface until a big case comes along.
Like the one we're looking at today.
Exactly. Leggett v. Hawkesbury Race Club Limited.
This wasn't some small settlement. We're talking millions awarded to a long-term employee.
Millions. For psychological injury caused by workplace harassment from her boss.
It really makes you stop and think.
It does. And this case, I think, signals something really important. The courts are increasingly recognizing just how profound this kind of harassment can be for someone's well-being.
Okay, so for this deep dive, we started with some initial reports.
Yeah, a couple of good summaries from BL lawyers and EI Legal. They flagged the case as significant.
But the real meat is in the court documents themselves.
Oh, definitely. The federal court judgments Leggett v. Hawkesbury Race Club Limited, No. 3 and No. 4. That's where you get the full story, all the details, the judge's reasoning.
Right. So our mission here is to unpack all that for you.
Yep. Pull out the key events, explain the legal side of things, general protections, negligence in harassment cases.
And crucially, what it means for employees and employers.
Consider this your fast track to understanding a really complex but super important area of employment law.
Okay, let's dive in. It all revolves around Mrs. Leggett. She'd been with the Hawkesbury Race Club for a long time.
A very long time. Started back in 91. By 2016, the judgment says she was their longest-serving employee.
Wow. So really established there.
Absolutely. Which makes what happened next even more, well, stark.
Because in May 2016, a new CEO arrives, Mr. Rudolph.
That's right. And almost immediately, things seem to change for Mrs. Leggett.
Can you walk us through those early interactions? What happened?
Well, it's pretty striking how quickly things soured. The judgment mentions a meeting May 18th, 2016. Mr. Rudolph apparently told Mrs. Leggett straight up that she was earning too much money.
Seriously? In one of their first meetings?
Yep. Even compared her pay to what she might get elsewhere. And the court actually rejected Mr. Rudolph's denial that he'd said that.
That's quite a way to start. And it didn't stop there, did it? There was that email exchange in June.
Ah, yes, that email. It really tells the story.
What did it say?
He demanded loads of details. Salary, bonuses, super, even remote work stuff. All with the same-day deadline.
A same-day deadline for all that?
Yeah. And the court explicitly linked this demand to his annoyance that she'd been asking about overdue commission payments.
Wait, so she was chasing money she was owed, and his response was this huge, urgent demand for information. That sounds, well, punitive.
The court certainly thought so. The judge put it plainly, said Rudolph decided to deny her bonus because he was irritated by her demands.
Wow.
And set her this repetitive, substantial task with an unreasonable deadline just to, quote, make her dance to his tune.
Ouch. And Mrs. Leggett's reply.
The judgment notes she wrote back, saying she felt he didn't trust her. After 25 years of transparent sponsorship work.
You could just imagine how demoralizing that must feel. Decades of service, and then this.
Exactly. And it seems she tried to address it. She called one of the directors.
Sid Kelly?
That's the one. In July 2016, she told him she felt micromanaged, harassed by Rudolph.
Did she say why?
Yeah, she was worried she couldn't get her work done for big race day because of all his demands. She literally said, I just can't work properly because he's constantly harassing me.
What did Kelly say?
He apparently reassured her, you've done nothing wrong, and said he'd talk to Rudolph.
So some acknowledgement there, maybe? That something wasn't right?
It suggests the board, or at least Kelly, was aware there might be an issue with Rudolph's behavior.
Then there was... Okay, this sounds weird. The chocolate wheel incident?
Yeah, it does sound a bit strange.
Early
June 2016.
What happened there?
Basically, a prize was advertised wrong, $500 instead of $50. Someone won. And Rudolph blamed Mrs. Leggett, even though she said another person, Mrs. Price, was responsible for that promotion.
But he blamed Mrs. Leggett anyway.
He did. And Mrs. Leggett said she felt so intimidated, she actually paid the club the $500 difference herself.
She paid it just to avoid trouble.
To avoid potentially losing her job. According to her testimony, which the court accepted, the court inferred Price was responsible and hadn't checked the prizes.
Paying for someone else's mistake out of fear? That really shows the pressure she must have been under.
It paints a picture of the power dynamic.
But things really escalated on that Flavors of the World race day, didn't they? October 9th, 2016.
Yes, that seems to have been a major catalyst. a critical event.
What exactly went down?
Well, Mrs. Leggett and some colleagues were invited by the assistant starter, Mr. Benson, to go see the barriers. Kind of a normal thing at a race club, you'd think.
Sure. Did you check if it was okay?
Yep. Checked her duties were covered, told Miss Porteous in the office where she was going.
But Rudolph found out.
He called her phone, demanded she come back immediately. Said she didn't have permission.
And this was in front of other people.
Yes, apparently in front of others. Caused her significant embarrassment, as you can imagine.
Being publicly dressed down like that.
Yeah, that's humiliating. Did she react?
She sent him an email afterwards. Said she felt very upset by how rude he was.
Did she mention other issues?
She did. She described it as a pattern being downtrodden, excluded, and questioned unreasonably. She felt they were reaching an untenable situation.
And she asked him to tell the board.
Yes, specifically asked him to inform the board about it all. So how did Mr. Rudolph respond to that? Was he concerned?
Well, his actions suggest otherwise. The very next day, October 10th, he emails her.
Okay.
Requesting a meeting to discuss her work performance. And suggests she bring a support person.
A performance meeting. After she complained about his behavior.
Exactly. He later claimed it was out of concern for her well-being, but the court didn't buy it. Said the email didn't reflect that at all.
And it gets worse, doesn't it?
It does. Just over a week later, October 19th, while she's off sick,
Yeah.
he emails the club's auditor, basically assuming she won't be back and asking for her payout figures.
Wow. Already planning her exit while she's on sick leave after raising concerns? That's cold.
It certainly seems that way. And then there was the issue with her commissions.
Right, the money she was owed from the sponsorships she'd arranged.
Yes, they were withheld while she was on sick leave, despite the fact she'd done the work to get the sponsorships.
Even though that was her entitlement.
The court found it was a clear breach of her contract, especially given the club's long history of paying commissions right after race days. Even Rudolph admitted she was entitled to them.
Okay, so just to recap the pattern here. Criticizing pay, unreasonable demands, undermining her, public humiliation, performance meeting after a complaint, planning her exit, withholding money.
It's quite a list.
Yeah.
You could see how that would build up and cause serious distress.
And she did try one more time with the director, Sid Kelly.
She did. Late October, early November, she emailed him again. Gave him a detailed rundown of everything with Rudolph.
Did she mention anything else?
She mentioned Rudolph had suggested a mutual separation during a meeting.
Right. So this all inevitably leads to legal action. What were the main claims she made?
There were a few key ones. First, a general protections claim under the Fair Work Act.
Okay, general protections. What does that mean in simple terms?
Basically, the Fair Work Act protects employees from having adverse action taken against them because they exercised a workplace right.
And a workplace right could be...
Making a complaint about your employment,
Yeah.
like Mrs. Leggett did about Mr. Rudolph's behavior.
Mm-hmm.
Or taking personal leave, like sick leave, which she also did.
Got it. And adverse action. What counts as that?
Things like firing someone, demoting them, changing their job to their disadvantage, or, hauling them into a disciplinary meeting, like that performance discussion, or removing entitlements, like withholding the commission.
Okay, so she argued those actions were taken because she complained and took leave.
Exactly. And here's the crucial part for these claims. The reverse onus of proof.
Reverse onus. Explain that.
It means once the employee shows, look, adverse action happened, and it happened after I exercised a workplace right.
Like making a complaint.
Right. Then the law presumes the action was taken because of that right. The burden then shifts entirely to the employer.
So the employer has to prove they did it for completely different, unrelated, lawful reasons.
Precisely. They have to convince the court that the protected reason, the complaint, the sick leave, played absolutely no part in their decision.
And did the employer manage that here?
No. The court sided with Mrs. Leggett, finding the adverse actions are taken because she made the complaint and took leave.
That's a really high bar for employers then. Significant protection for employees. What were the other claims?
The second big one was negligence. Common law negligence.
Okay, how did that apply?
Mrs. Leggett argued the race club, her employer, had a duty of care to protect her from a reasonably foreseeable risk of psychiatric injury.
And the bullying behavior created that risk.
Yes. The court agreed. It found the club was negligent because of Mr. Rudolph's bullying, and importantly, because the board failed to act even though they knew about it.
Because she told Sid Kelly.
Exactly. The court mentioned the Kohler v. Cerebos case, a key case on employer duty for psychiatric injury. But the difference here was that Mrs. Leggett had clearly communicated her distress and the problematic behavior.
Unlike in color. So the risk of psychological harm was more reasonably foreseeable for the employer here.
That was the finding. They knew or should have known and didn't take reasonable steps to prevent the harm.
So duty of care breached, negligent, what else? Breach of contract.
Yeah, that was the third claim. Pretty straightforward. Failing to pay the commissions on time breached her employment contract, especially given their past practice. The court agreed on that, too.
And there was a workers' comp claim running alongside this?
There was. A Workers' Compensation Commission arbitrator had already found she suffered a psychological injury between May and October 10th, 2016.
Caused by the bullying and harassment.
Yes. And they determined the deemed date of injury, which is related to when she became unable to work due to the injury.
Okay, now the really complex bit you mentioned earlier. The clash between the Fair Work Act compensation and the workers' comp system.
Right. This became a major legal point, even involving constitutional law arguments.
Federal law versus state law, essentially.
Kind of. So the NSW Workers' Compensation Act has caps, limits, on how much compensation you can get for certain types of work injuries, including psychological ones.
And the race club argued those caps should apply here.
They did. They argued that any compensation Mrs. Leggett received, even under the Fair Work Act claim, should be limited by the state workers' comp laws.
But the federal court disagreed.
Disagreed strongly. The court ultimately ruled that the limitations in the State Workers' Compensation Act do not apply to compensation awarded under the Federal Fair Work Act for breaches of its general protections provisions.
Why not?
Because the Fair Work Act is a federal law, and under the Constitution, where federal and state laws conflict on the same topic, the federal law generally prevails. The court found Parliament intended the Fair Work Act's compensation provisions to operate fully, without being cut down by state limits in this context.
So the multi-million-dollar award wasn't restricted by those state caps.
Exactly. The significant amount awarded covering past and future economic loss, pain and suffering, loss of enjoyment of life, was calculated based on the Fair Work Act principles, without applying the workers' comp limits.
That is a massive difference. Did they account for the workers' comp payments she'd already received?
Yes. The court was careful to adjust the final award to prevent double dipping, making sure she wasn't compensated twice for the same loss. But the potential compensation under the Fair Work Act was vastly higher because those state caps were irrelevant.
Okay. Huge implications. So let's distill the key takeaways. What should employees take from this?
I think the big one is understanding your workplace rights under the Fair Work Act, especially the right to complain or raise issues without fear of retribution.
Adverse action.
Right. And this case shows that if you suffer psychological harm from bullying, the potential compensation can be very significant indeed. That reverse onus of proof is also a really powerful tool for employees.
If action follows a complaint, the employer has to prove it wasn't connected.
Puts the pressure squarely on them.
And for employers, this sounds like a serious wake-up call.
Oh, absolutely. Several key things for employers. First, evidence is crucial. If you are taking disciplinary action, you need clear, documented, legitimate reasons to rebut that presumption of unlawful adverse action.
So document everything properly. Meeting minutes, warnings, the rationale.
Exactly. Second, you need checks and balances, especially on managers. Ensure decisions aren't being made for prohibited reasons, like retaliation for a complaint.
Like maybe the board should have stepped in sooner with Mr. Rudolph.
Well, the court found the board's failure to act was part of the negligence. So, yes. Third, that duty of care to prevent foreseeable psychiatric injury is real and has teeth. Ignoring bullying is not an option.
The financial consequences are just too high.
Potentially millions, as we see here. And finally, understand the interaction between fair work and workers' comp, but recognize that for Fair Work Act breaches, federal law remedies are likely to take precedence over state limitations.
So the big aha moment here really is the scale of risk for employers if they get this wrong.
Definitely. It's not just about unfair dismissal anymore. General protections claims, negligence claims, they can lead to massive payouts for psychological injury, far beyond what many might expect.
It broadens the whole scope of liability, doesn't it?
It really does.
This has been, well, quite the deep dive. It really makes you reflect on your own workplace, you know.
Are there proper systems? Are complaints taken seriously?
Do people actually know their rights and their responsibilities, too? It's worth asking yourself, you listening now, how does your workplace stack up?
Are there clear processes? Is the culture one where people feel safe to speak up? Or is it something else?
If you do want to dig deeper into this, the Fair Work Ombudsman's website is a great resource. Lots of info there.
Definitely. And look, if you find yourself in a situation that feels like what Mrs. Leggett went through, getting proper legal advice from someone specializing in employment law is really important.
Because understanding these complex issues isn't just for the lawyers.
No, it's vital for creating workplaces that are actually fair and safe for everyone involved.
Couldn't agree more. A crucial point to end on. Thanks for joining us for this deep dive.